All right. Okay, everyone. Hello, hello. How's everyone doing? Good, good. Everyone have a nice weekend? Nah. Texans? No? Dallas? No? Well, today's actually been a really busy day, as you might understand. This morning, the Supreme Court blessed us all with a surprise decision. So this is actually germane. We'll do a little bit of marital point this year, so it actually is relevant to our studies. So there were appeals from numerous courts of appeals to the Supreme Court involving bans on same-sex marriage. And there were a lot of them from many different states, from Virginia, from Utah, from other places. And it was largely expected that the Supreme Court would maybe wait until all the cases decided and kind of hold these off. But today, and it's a decision that surprised everyone, myself included, and that's why I'm somewhat frazzled, the Supreme Court denied review in all these petitions. So the effect of this decision is that now in 5 states, and by next week probably another 6 more, the bans on same-sex marriage will just be invalidated. So by not granting a review, the Supreme Court has effectively passed on the issue. And what's remarkable is that there's a foreseeable chance the Supreme Court will never have to actually decide this issue. If they deny a review on every single one and every lower court invalidates the rule, the Supreme Court will just totally duck the issue, which would be frankly stunning. And no one predicted that. If anyone told you to predict that, they're lying to you. No one saw this coming. So that was a very good development this morning. Now I'll tell you one of the few possible wrinkles, actually, unsurprisingly, comes to this, right? So there's actually 2 possible Texas cases pending. One is pending for the Texas Supreme Court, and it's actually been there for about 2 years, and they haven't done anything on it yet. I don't know what they're waiting for, but they will have to probably get to it sooner rather than later. Also, the Fifth Circuit Court of Appeals, which is based in New Orleans, is considering it a Texas law, and we're going to have arguments on that probably in the next couple months. If either of those courts upholds the ban on same-sex marriage, then the Supreme Court will have to take it. And at this juncture, it's almost a fait accompli. There's a very low chance the Supreme Court will uphold any of these bans. For the simple reason is by the order today, they've allowed marriages to happen in like a lot of states. And there'll be thousands and thousands of people who get married with these licenses. And it would be stunning if the court were to suddenly turn around and say, oh, no, just kidding. That's not necessary. Those licenses are not valid. So today was a really big day. You know, first Monday in October, the first day of the Supreme Court term, which had a huge shock before the first case was even argued. One thing that drives us crazy about the Supreme Court is they don't give us any notice. There was no fanfare about this. In a 90-page document, there were 7 lines that indicate they denied reviewing these. And the worst part is, to the reporters at the court today, they omitted those pages when they had the paper copies. Only an hour later, they posted an electronic copy, which showed these 7 lines indicating these 7 cases were denied. So this was a very frantic morning for those in this realm. So I share that with you. It was very hard for me to talk about executor interest this morning. I really had to will that one. But I think I'm okay now. I'm okay. But yeah, the Supreme Court keeps us all surprised. They don't give us any notice but anything. Yeah. No, smoking mirrors, pills, and potions, I don't even know. So where do we go from here? Easements. All right. Any questions about that before we go on? Any questions? All right. This is our last class on easements. Okay, last class on easements. And our goal today is to talk about some of the peripheral issues, like how to assign easements, about the scope of easements, and what happens when you want to terminate an easement. Next class I'm going to give you a preview is on covenants. Read those pages very carefully. Covenants is probably the most annoying topic for an entire semester. It was like future interest in property 1, covenants for property 2. This is, again, a topic of law that's based on a lot of arcane common law procedures that don't make much sense anymore, but we're still stuck with them. So I implore you to read very carefully the readings for class on Wednesday and try to actually get it yourself. If you don't get it completely, that's fine, come to class, but this one really take the time to read. Okay? All right, any questions before we get started? All right, let's do easements. So, mini, easy, simple review. Where did I finish last time? What was it? All right, thanks, you. All right, so Ty, which way is it going? This way or that way? That way, okay. She points that way very quick. All right, Ty, remind us, what's the difference between an easement appertenant and an easement in gross? What's the difference?
Appertenant to the land, and gross to the person.
Full sentences, please.
Appertenant is to the land.
So, subject and verb. What to the land? You need a subject in there.
Oh, the right, the easement.
Very precise where I'm looking for. It begins with a B.
Belongs.
Oh, Jane. Benefit, yeah. You're just missing your subject. You had your verb, though. Okay? Yes. With an easement appertenant, the benefit belongs to the owner of a piece of land, right? Whoever happens to own that land at a given time, that's who's benefited. With an easement in gross, an individual receives a benefit to land in a certain way, and that easement travels with him wherever he lives, wherever land he owns. Okay? We also have these other expressions. V, what's the difference between a dominant estate and a servient estate?
The dominant is the one who benefits from
Good,
the
yes.
easement versus the servient.
It's burden.
Is burden.
Yes, good. See, you got your subject right, but not your verb right. Yes. No, you're good. The dominant estate is the estate who receives the benefit, and the servient estate is the estate that's burdened by the easement. Okay? Everyone get that? Okay. That's all last week. So the first case we're doing today, this Miller versus Luther case, this is not an easy fact pattern. We'll take some time. She's smiling because you know she's next. Right. This is not an easy fact pattern, so we'll take some time to walk through this. This case is actually very good because it unites our topic on prescription and easements with our topic on adverse possession with our topic on prescription. It blends the two issues in a very messy fact pattern. So actually, I Googled this place. This Lake Naomi Club's apparently still there, and it's next to this huge lake. And here are actually some photos of people boating, right, but not bathing. By the way, okay, so Brittany, what's bathing? I always have to say this every year because always someone doesn't know what bathing means.
Are you asking?
Yes. Yeah. What's bathing mean in the context of a lake?
I don't know because I've never done it. So.
Swimming.
Oh, well, see, I can't swim. So.
Okay. Bathing means swimming. Okay. If you see this picture, they're boating, they're fishing, but they're not swimming. So one of the important issues in this case was, could they swim? Okay. And you see all these pictures. All right. So, Brittany, high level, what was the major dispute here? We'll go into the details of the easement and English later. High level, what was the dispute here?
I think when Frank died, he had like 3/4 of the rights, and the thing was is 1/3 of the rights to move to him so the people sunbathe. You know, the bathing rights.
Swimming. Yeah.
The swimming rights moved to him.
Right, okay. All right, good. So the dispute we have here, right, is you had these two brothers. And for a number of years, they had operated a club by the lake where people would go swimming and boating and whatever else, right? At some point, and we'll get to the details in a minute, but at some point, one of the brothers died, and this partnership and the family fell apart. And the surviving brother tried to transfer his interest to this other church, okay? So then the dispute that actually came to this court was between the family of the first brother who died and this church. And they were trying to see whether there was actually an easement transferred to allow people to swim in the water, okay? So let's do this timeline step by step because it's actually somewhat draconian and annoying to follow. This is property 2. Okay. Not 12. Okay. So first step, right?
It's
Here's Zoe.
It says here that the surviving brother isn't the one who tried to do this. It was the estate of the dead brother who tried to transfer the interest.
We'll go through the facts in a minute. Yes. Okay. All right. So let's go start with Lee. All right. Let's try and walk through these facts. Okay. So at the very outset, right? Who owned the land at the very outset before anything happened?
I believe that was Frank Miller.
Good. Well, even before Frank got it, right? What about this corporation, right? So what was like the first transaction that was done in 1895?
There wasn't, I guess, Frank received it from the corporation.
Okay. Well, let's do like this. In 1895, right? This part is not particularly important, so I don't care so much about it, right? Frank and Rufus, right? They leased the land, and let's get the company name right, to the Pocono Spring Company, right? Right? This water ice company. By the way, does everyone know why it was called the Pocono Spring Water Ice Company? I always have to ask this, but everyone know why? Yes. Yes. Yes, this surprises people from Texas. When you have a lake in Pennsylvania in the winter, it gets cold and it makes ice, right? And before refrigeration, the way to get ice was to go to a lake. Everyone get that? I explained this because people in Texas, that might not be obvious. Okay. So during the winter time, they would take the frozen water, which is also what we call ice, right? And then they would sell it. Okay, so they leased the land to the Pocono. What are you laughing? I once had a student sitting right there said, "Isn't that gross that people swim in the same place to get the ice from?" Like, do you agree?
Yes.
All right. Okay.
So do they just go and get the ice every time it refreezes?
Yes.
Yeah.
Yeah. Every winter, the water refreezes.
Yeah, but I mean, once they mine out the ice.
Well, there's a thing called rain, right? Like,
Right.
remember, down came the rain, and it refills the lake. There's a thing called a water cycle, right?
Just clarify.
Yeah. No. Yeah. Exactly, Texas. All right. Actually, I think Zoe, you're next. So let's walk through. Let's walk through the facts. Okay. All right. So what happened after the initial 99-year lease? Let's go year by year.
Well, then afterwards, afterwards in 1899, the company granted the right.
Oh, before 1899, what happened in 1898?
1898. That's not here. It's not here. It says 1895 and then 1898.
It might come later. There was a mortgage, wasn't there?
Oh, right. Okay.
Okay, so I'll fill that in because that one's not too important. So the Pocono Springs, right, places a mortgage on the property. Okay. Okay, Zoe, what happened then in 1899?
Then the corporation
Good.
granted back to Miller some rights.
Which one, Frank or Rufus?
Frank Miller.
Okay, granted to Frank.
And
Good.
gives him the exclusive rights to fish and boat in all of the waters.
Okay, good. Stop right there for a second. Okay, that's right. So there was an easement given now, let's be very careful, from the corporation to Frank, right? Which included the right to fish and the right to boat. Zoe, did you say anything about the right to bathe or swim? Okay. So one thing about easements, right, is that they're very specific. They're very specific. If I give you the right to boat and fish, I don't give you the right to swim, right? Now, Clement, why does that make any sense? Why would anyone even care about whether you're swimming or boating? What difference does it actually make?
Yes, there's some like commercial purposes of what they were doing.
Right. Hey, maybe I can think of one reason. If they're swimming, they just put a lifeguard up there, maybe? Right, if you're only having boating and fishing, maybe you don't need to have the same kind of a safety preparation, right? Maybe the water isn't so clean. Maybe Claire's right about that. Maybe you don't want people swimming around in that water, right? So you can imagine why someone said we only want boating and fishing being done in this water, right? Okay. And also one thing that might be odd for you to get is the corporation, which is basically owned by Frank, is giving an easement back to Frank. But don't let that fool you. The corporation is a totally separate person, a separate entity. Okay? All right, Daniel. So what happened next in 1900? Whoa, be very careful. Does you also include, say it again, so 1/4 interest in fishing, boating, and what was the last one? Okay. So this is where, that's correct. This is where it gets a little funky, right? We just said a minute ago that in 1899, Frank only received fishing and boating. But as Daniel just said, in 1900, right, they get the rights to, and not just all the rights, 1/4 of the rights to fishing, boating, and fishing. I'm sorry, fishing, boating, and bathing. And that means swimming, right? So I want to see the problem, right? So Daniel, at this point, could Frank actually convey this 1/4 interest? Okay, that's right. But again, just because you can't convey an interest doesn't mean people don't. In fact, I promise you, on the exam, people will be conveying stuff they don't actually own. I 100% promise you that'll be on the test. Okay. All right. So then, what happens next in 1902? Okay. So, other Daniel.
What happened immediately afterwards was they started a business partnership.
And then 1903 also.
Oh, the property of the company was sold out.
Okay. So basically, this business by 1903, the business was shut down, right? The bank foreclosed on the mortgage. Specifically, the bank foreclosed on the corporation who actually held the land. That a 99-year lease, if you recall. Okay, and we studied mortgages in this class. And Heath, after there's a foreclosure sale, after the foreclosure, what happens next?
What year?
In general, after a bank forecloses, what happens in general? No, what happens first? When there's a foreclosure, what happens? No, don't you remember? Omar?
There's a foreclosure.
We did foreclosures, right? I'm not going crazy. I sometimes forget where we are in the semester. After someone defaults on the mortgage, what must the bank do?
Give them notice.
And then,
Try to look for other buyers.
and what do you call that thing? Brooke? It's on the board. Wow, guys, you gotta. We did this 2 weeks ago, 3 weeks ago. We did do this, right? Am I not delirious? Sometimes we go out of order, but yes, we did this. After a bank forecloses, they hold a foreclosure sale, also called a sheriff's sale, which was referenced in the case, right? A sheriff's sale. All right. So go back to you, Heath. What happens at the sheriff's sale? What do you think happens? Right. Other people can come and buy it. Okay. So Lamar, who comes and buys at the sheriff's sale?
The deceased brother's wife.
Well, be more precise. Which company bought it?
I don't know.
Brooke? It's in there. It's in the case. All right. Do you know the name of the company that bought it? Rebecca? Pocono Pines, right? In the case, it's in there. So another company went and bought it off the foreclosure sale. But who owned Pocono Pines, Rebecca?
Wasn't that the brother's wife?
Well, it was a brother, then the wife by death. But yeah, basically, yeah, Frank owned it, right? So here's what happens. This is actually kind of weird, right? Frank lets the bank foreclose on the property by Pocono Springs and immediately buys it back as Pocono Pines. What do you think he was doing here? Cut the brother out? Oh, right. Because the brother had a stake in this other company, right? But he was thinking, oh, wait a minute, I just cut my brother out. All right. So then that was 1903, right? Nothing happened then until 1925, right? Throughout this entire time, every single summer, Frank and Rufus were working this, the lake. They had people swimming, fishing, boating, and bathing, right? All right. What happened during that time, Stephanie? Even though the parties didn't initially have an easement to swim in the land, what happened subsequent to that?
So from 1900 to 1925, the brothers worked together. They had like the boat and bathhouses at different points on the lake.
Uh-huh.
So they like purchased it and built it.
What do you call, now, during that time, did people swim in the water? What do you think? Yes, people swam in the water. Did they have the right to swim in the water? Was there an easement for that?
Not necessarily.
No, the answer is no. Okay. What do you call it when you do something for a long period of time without permission? What do we call it in this class, at least? Prescription. Yes. Okay. So, Hugo, did they establish a claim to prescription for those 20 whatever years to have people swim in the water?
Yes.
The answer is yes. Why? Let's go through the elements, right?
It's gonna be
Was it open?
Open and Florida.
Yes.
It's in the right side.
Right. Was it hostile? Was it against the claim of right?
It was,
How do we know that?
because they didn't want them swimming.
Right. The easement simply said no swimming, right? Or it was silent on that. Okay. Was it continuous?
It was continuous throughout the entire time.
And did they assert a claim of right to it?
Yes.
Okay. So during this time, right, during this 25 years, they gained a prescriptive easement for bathing. This is kind of a weird dynamic because if you think about it, they're squatting against themselves, right? The land was owned by this corporation, and the shareholders were Frank and Rufus. But at the exact same time, they were the ones who were squatting. But it doesn't matter. You can actually squat against your own corporation. It's a weird sentiment. This is why people always get upset. Oh, corporations are not people. Yes, they are. They're treated as people in virtually every aspect of the law. You can actually squat against yourself as a corporation, right? I mean, it's odd to say it's adverse, but it certainly was. So what's interesting, and this is one of the trickier parts of the case, is during these 20 whatever years, they gained a prescriptive easement for bathing, right? So now we have this doctrine, right, of something called equitable conversion. Do you remember reading about that at any point, equitable conversion? So check this out, right? In 1893, right? I'm sorry. In 1900, 1899, right? In 1899, Frank did not receive the right to bathe. Everyone agrees with that, okay? In 1900, Frank purported to give Rufus a quarter and leave 3/4 for himself, right? They didn't actually gain that right till about 1912 or whatever, right after 10 years. So here's what the law actually does, which is funky. He didn't have it here, but he got it here. So we make believe. We pretend, because he gained it here, as if he had it in 1900. This is probably the weirdest part of the case. There's this doctrine of equitable conversion, which basically says the equity does what ought to be done, right? So even though this was a fraudulent conveyance in 1900, he eventually got it. He got the right to bathe. You go back in time and you pretend he had it there. You actually pretend he had it in 1900. So the conveyance here is actually treated as if it were valid.
Is that the same thing as after acquired title?
Yes, explain. I think you're on the right track, but explain what you mean.
So if you convey something, like if you have, like there, or I guess if you have only a quarter interest and you convey a half interest in some piece of property, they only get a quarter interest, but if you later acquire that last quarter and thereby actually end up with a half, it automatically goes to the other person.
Basically, yes. So to summarize what he just said, it's often the case where I fraudulently sell you a piece of property, right? I then obtain it, and effectively it's transferred to the buyer. Law treats as done that which ought to be done. So if I fraudulently sell you Blackacre and I actually buy Blackacre tomorrow, you're actually the owner of Blackacre because all the steps are there. They just were in the right sequence. So here, they actually obtained the easement 20 years after they transferred it, right? But the law pretends that they were able to transfer it when they actually had it. Law pretends they actually relate back that it was able to be transferred there. It's a fiction. This is not reality, right? It's not real. But equity does it. Okay, everyone see that? Okay, so for all these 25 years, they'd actually gained it through prescription. Okay, everyone see that? Okay, Shamara, what happened then after what happened in 1925 then? You got it? No? Eric, what happens? What happens in 1925? Yeah, Rufus dies. Yeah, okay. Rufus dies 1925, right? And then what happens after Rufus's death? What's put into place?
Frank's wife tries to claim that Rufus doesn't have an interest.
Well, more precisely, you're right. So in 1928, what happens is Frank's wife, right? She basically inherits Frank's claim. She now owns it, right? So now Frank's wife, okay, owns Pocono Pines, right? Let's go back up here. The wife who owns Pocono Pines thinks that she has the easement, okay? The question is who actually has it, okay? So then in 1929, the executor to Rufus's estate grants a license to the Lutherans, right? So let's be very precise here. Okay, so Artemio, in 1929, right, when Rufus's executor makes his grant, what interest did Rufus's executor have in the bathing rights?
Prescriptive easement?
Yes. What percentage?
Quarter.
Exactly right. Okay. So what's interesting is that Rufus had the quarter right to bathe, and he gained that through prescription. Okay, so tell me, who owned the other 3/4?
That would be the Pocono.
Not Pocono.
Cat.
It would be the estate of R. Right? I mean, I'll say of Frank. Frank had the other 3/4, right? So it would probably be Catherine because that was his wife. But the estate of Frank has 3/4, and the estate of Rufus has 1/4. Everyone see that? So in theory at least, Sean, what interest could Rufus's executors sell to the church? What could, in theory, don't worry about the one stock yet. What could he transfer?
Yeah. I mean,
What interest did he have to start with?
He served with 1/4 interest.
Right.
So he got his son just his 1/4 interest.
Right. Okay. So how would that work to swing 1/4 of the lake? I mean, it doesn't make any sense, right? So an easement like this is actually a good illustration. It's very hard to chop up easements, right? Would anyone ever buy a 1/4 easement? John, would anyone ever buy a 1/4 easement to swim in, like, 1/4 of the lake? I don't know how, which quarter?
It depends on what it would be for. Maybe it was like for oil, right? I would take 1/4 of the profit.
Well, see, oil is easy to divide because you can just divvy it up. You have X number of gallons, whatever, you can divvy it up. With a lake where you're swimming around, you can't really do that. What would have been the smart way for the Lutherans to have obtained an easement here? Who should they have also talked to?
The other party.
Who is that?
Rufus.
Well, Rufus is dead.
Then his wife. Whoever he sold it to.
Well, Rufus sold his quarters. Who else would she have talked to?
I'm sorry. So the wife of Frank.
Yes.
Talked about?
Okay, so the correct way for the Lutheran Church to have done this was to have obtained the 1/4 interest from Rufus's executors, and they could obtain the 3/4 interest from Frank's executors. At which point they would have the entire easement and they could swim the entire lake. No, you can't section a lake off. It doesn't work. You can't.
Is that undivided too?
Yes, I think it's effectively it's an undivided easement, right? So you can't really divvy it up. So I want to see, this is actually, one second. This is actually what we would call the one stock rule. Okay, and this is what the court alleges or describes, right? You need to have basically both parties who are owning an easement to transfer it. And I think we just illustrate the reason why. It doesn't make sense to only have a quarter of an easement. You can't swim on that. What happened was Rufus's executors tried to transfer way too much, more than they actually had. All you could transfer is 1/4. And at Pennsylvania at the time, under this one stock rule, you could not do that. Okay? So in other words, under this one stock rule, right, you're able to transfer it only when both parties, all the easement, come together. And then you transfer 100% of it. Zoe?
Yeah, I was wondering, why would they go to Frank's wife? Frank was still alive at this time.
Well, whoever held, I think for whatever reason, his wife held some of his interest. I'm not exactly sure why.
Yeah, he and his wife both filed suit.
Right, so they could have been Frank or his wife, whoever held the interest, right? Okay? So it doesn't even matter who holds it, but they should have gone to both of them. Who messed up was Rufus's executors sold it when they couldn't sell all of it. Everyone get that? All right, so this case is tricky for a number of reasons, and I think this timeline helps illustrate that, right? So first you have a conveyance where they're trying to give an easement they don't actually have, right? You can't do that. But then when they actually gained it together through prescription, you relate back and you pretend as if they had it in 1900, okay? And then each of them had a 3/4 or 1/4 interest in the swimming rights. But at the very end, Rufus's estate could only transfer the interest he had. He could only transfer that 1/4, and because Frank and Catherine, however they didn't agree, the entire transaction was void. So in this case, the church is in the wrong. Okay. Questions on that case? So the facts of the case are trickier than they should be, but I think it's a good case once you get to the core. Any questions in that case? All right. So they note in the comments afterwards that for the most part, this one stock rule has been abandoned. I don't know any states that actually have this rule. Under most modern trends, they have they allow you to divide it up. Now, practically speaking, I'm not sure how you divide up a swimming easement. It would actually be pretty messy. I don't think you can section off the lake. So I'm not sure how this would actually work. But for the most part, you can have one party transfer their share in an easement. And as John said, with oil royalties, it's often done we have a fractional share in whatever mineral interest you may have. Okay? All right, questions on the first case?
Are you going to want us to follow the one-stop rule?
Let me put it this way. If I want to test you, I want to say the one-stock rule applies. And if I say nothing, assume it doesn't. Like I would specifically tell you under the one-stock rule what happens. But otherwise, assume it doesn't exist. Yeah, that's why the case is unsatisfying. It's like you really think you got to the end. It's like, oh, this one-stock rule. Then I lose it. Then like it throws it away. But then it doesn't make as much sense. Okay. All right, let's do the second case. The second case involves our favorite Hood Canal. You might remember we did the case of Howard versus Acunto. Remember that's also in the Hood Canal? And remember the issue there was everyone's property was located like 50 yards off from where there should have been. And basically everyone had to move over like one lot. Well, it seems here we have a similar issue along the water where the property lines are not exactly right. All right, so Derek, walk us through what happened in Brown versus Voss.
Okay, so this is, yeah, plaintiff owned a bed. Again, that's land.
Uh-huh.
And they had an easement for use of the fence. Brown.
Okay.
Brown has it right there. Brown eventually buys the, I guess, he buys the section next to the dominant land. And then end up, I guess, Voss put up a bunch of like construction down there.
Okay. So good. So that's right. So here's what happened in this case. We're dealing again with landlocked property, right? So see this nice little red squiggle? Right, that's a road, in case you couldn't tell. So what happened was we have three parcels. We have A, we have B, and we have C, right? The owner of A, right? Sorry, there was an easement to cut across A and go on to the tip of B. And the general idea was so that the owner of B could get to the main road. Okay? We don't know anything about the owner of C before this. For whatever reason, maybe had a helicopter, we don't really know. But C had no interest in actually getting off of his land. That might seem something of an anomaly, but we don't have any information about that. So the easement said, okay, that the owner of B could travel across this road along A to get to the main road. Yeah.
I know it's not like what we're reading it. Doesn't make sense. He owns B and C. How is that not one parcel?
He didn't own both of them at once, though. So let's be very precise. The easement said, let's talk about dominant and servient, right? Under the original easement, which was a dominant estate? B, right? Which was a servient estate? Okay, it named two pieces of land, right? Did it name C? There you have it. When you name a piece of land in an easement, you have to be very precise. If you say the benefit is for the benefit is for the owner of B, that's all you say. You say nothing about C.
But I guess how do you know? Okay, so there's one road. B is here, C is here. You own both of them. How do they know? You just say, "Oh, don't worry. I'm always trying to get to B, not to C."
Well, let's do the facts and you'll find out what happened, right? So, Catherine, at some point, right, B decides to build, the owner of B decides to build a house that straddles the property line. It's part on B, part on C, right? What does the owner of A do when he finds out about this new house on the line? Before he gets the injunction, he does the jerk thing. He puts up what's called a spite fence. Anyone ever hear about this? This happens a lot in property disputes where there's only one way off this lot, and it's through this road. And the jerk puts up a fence and puts down concrete, and he makes so he can't pass. So effectively, he landlocks the other house, right? Captain, why does he do that?
Because he doesn't want them to use the road.
Okay. Alex, why do you think he was so adamant that he didn't want to extend this, that he didn't want people from, the house that's on the line from coming across to see? Why do you think he was so angry about that? Well, even more than that. Let me ask you this, right? What happens if, say, okay, well, in the abstract, right, will there be any increase in traffic, Alex, because this house straddles the border? Will there be any increase in traffic?
No, I don't think so.
Right. The same guy's living there. He only has one car, right? Haley, what happens if the owner of C, it's a fairly big lot, builds another house on that property? Ah, could the owner of that house then cross across the land? Okay, and say they build a condominium building right there on C, and now there are 20 new families living there. So you see the problem here, right? You might say, oh, what's the big deal? The guy's house is 5 feet over the line. There's no new traffic. There's no new burden. Why is he getting so upset about this? Well, once you allow someone to cross your land, they may add additional houses there, right? And Katie, what do we know under adverse possession? What happens if he knows they're crossing, lets them do it? Say for 10 years straight, the owner of C starts crossing the land, and A knows about it, does nothing to stop him. What happens then? What do you call that? When you do something for a long time? Oh, where? Say.
Like committing them, so it's.
No, but there's a word we did in the last case.
Yeah. Prescription.
That's it. Prescription. Exactly. Prescription. If A knew that all these other people living here were crossing over and did nothing to stop them, then they gained a prescriptive easement. And not only if the easement is silent about C, now the court will find one. Zoe.
What if they just were what if they had just been very vocal about telling, it would have been so much easier if they just been very vocal about telling these guys, you only have an easement as to parcel B, not parcel C. You are using this road to get to parcel C strictly with our permission. Wouldn't that do?
Well, they could do that also. What would the benefit be of doing it permissive?
Well, that way they can withdraw it at any time. So right now it's not that much. It's not any extra traffic, so they can.
And
just let
what
the
if
guy
it
go
does
to
damage to the road? What if it's a dirt road and they're doing damage to it? That doesn't help them.
I'm just saying that way they don't have to be assholes about it. But
Well,
if someone decides to go and build
it's
a bunch
not-
of more other houses there, or like a condo, like you said, what you said they were worried about, then they can just say,
Well,
withdrawing permission.
There's a couple things to worry about, right? You're worried about, on the one hand, an adverse possession claim to a description, right? You're also worried about them doing damage to your road. This might be a dirt road. You have to do maintenance, upkeep, and regrade the road. So I think I don't think he was being an a-hole. I think he was being smart. I think he did what he had to stop them from abusing his land, where they probably would have gotten an easement by prescription at some point, right? So that's in theory what should have happened here, right? So if I understand, like where the guy with the fence was coming from, right? So Adam, how did the Supreme Court handle this case?
They said that it virtually, I mean, it was breaking the easement, but they said that.
Oh, but before we get to the but, see what's interesting about this case is when you're reading it the first couple pages, like, oh man, they're going to rule against this easement, right? They're gonna rule against it. So before we get to the but, how does the court say? How does the court construe easements? Generally speaking, what's the rule of what what the easements say?
I believe the general rule. I mean, it's pretty.
Let me ask like this. Yes, exactly what I was looking for, right? So they say, generally speaking, if the easement says dominant is B, servient is A, that's it, folks. That's it. And it's a misuse of the easement to extend it even 1 foot beyond the property line onto C, right? So generally speaking, it's a misuse. Even if there's no burden, right? Okay, so I made up all these fancy examples, like building a condominium, right? We have here literally a house with a corner of it over the line. There's no new people living there. It's exactly the same, right? But generally speaking, the courts say, you know what? This might create a bad precedent for the future. There might be prescription. We don't extend easements, right? Right? Kevin, if the owner of C really wanted an easement, what could he have done?
Ask A for it.
Oh, maybe more than ask.
Done it. Pay for it.
Pay it, right? So if C really wanted this, he could have given B a lot more money. I'm sorry, he could have given the owner of A a lot more money. Everyone see this, right? If the owner of the house on B really wanted this easement, he could pay for it. So historically, common law, courts are not going to be extending easements, right? But then we get to the but, right? I cut Adam off when he said but. So Monica, what's the but here? At the very end, the court quickly turns around. What did they say? So it's almost like you miss it if you read too quickly. You gotta talk louder. Explain. What did the court actually hold here? At the very end. Who won here? The owner of the house on the border, or the owner, or the owner of A? The owner of the house on the border, right? Why did he win, even though the easement was limited to B? The easement said nothing about C. Why did the court extend it? Later, you have it? I'm sorry? Equity. Exactly. Equity. Later, how is this equity? What about the general rule that you don't extend easements? Why did the court do this?
Because they said that like the guy from B wasn't gonna suffer anymore because they said that there wasn't gonna be more cars passing through, that, but like, when they balanced it out, like, who's gonna have more,
Right.
who's gonna suffer more? The owner B and C would suffer more because he would be putting it to his house.
Right. So yes, that's right. So effectively, based on equity, right? Based on equity, the court said we'll extend the easement. So now, even though the original easement only said B is dominant estate, now it says B and C are the dominant estates, right? Forever, A's title will now have one more easement on it. A's title will forever be encumbered by this additional burden. And the court pays absolutely no service to the fact that another house could be built. Sure, there's no burden today because there's only one guy living there. What if they build another house or a condominium or whatever it is, right? What if they build a dock by the beach? So the majority opinion is somewhat problematic. What does the dissent say, Victoria? Yeah, the dissent's short and sweet. It's like, listen, we have a rule. It makes sense, right? People act in conformity with the rule. When A put up the spite fence, right? When A put up the fence, he was relying on the fact that he didn't need to give permission to C. When A put up the fence, he was acting entirely in his rights. But now, again, they've changed the common law rule and they did something that's more fair. And the value of A's property just got diminished. And Victoria, did B have to pay anything for that value? No. And not only that, he had to pay for litigation costs. And because he was a prevailing party, he probably got fees. So really, A got screwed here from top to bottom. He lost his land with the easement, and he lost all the cost of litigating this to the Washington Supreme Court, and he probably had to pay the fees for the other party. Sucks to that, right? So that's what happened when you dump the common law. But now we know in Washington and perhaps elsewhere that the rule is, well, if the easement is whatever, we can extend it. Yeah, Zoe.
Isn't that made even more unfair by the fact that even though it's not noticeable in this map, don't all three parcels already have access to the main road?
Well, you can't. I think this is a modern picture, and at some point, access to the main road was given. I don't think it was there initially.
It was. It says afterwards. After the case, it says in the textbook that that all three parcels had access to the main road, but the court didn't know that because the map that was submitted was inadequate.
Right. So as far as the court was concerned, the roads weren't there, and I tend to think the parties would have mentioned that. So I'm not quite sure exactly how that was missed.
Also, parcel B was a lot smaller than shown on the map. It was pretty much just this tiny strip of land.
Mm-hmm. So one other issue that Zoe kind of alluded to, why didn't the government make roads? Because, I mean, you see it's facing a public highway, right? Why didn't the government simply make roads going across, right? Why couldn't the government effectively condemn or use the power of eminent domain to seize this little strip here and make a little outlet from C, right? The government could have done that also. But instead of using the power of eminent domain to actually build a road, which is a correct use of eminent domain, there are lots of not so correct uses, they effectively forced an easement across two other people's land. Yeah.
Same, like, I guess the little strip next to the public highway in between their land and the highway.
It's not the government's land. It'd be the private land, right? Who owns this little strip next to C? Probably C.
What extent can you
Yeah.
your land to a public road?
Yeah. The government could have condemned the tip of C's land and made a road right there.
No, could C do that? What extent can C try and connect?
Off topic, but they would probably need to work with the government. They would probably need to say, hey, government, we'll give you this land for you to build a road. And the government may allocate highway funds to do that, which is not a given.
And you can't gain an easement to government.
I mean, you could chop down your own trees and make a dirt path leading to the road. No one can stop you doing that. Right? C could have chopped down these beautiful trees buffering the highway and said, okay, I probably didn't want to do that. C wanted to go like this. But now think about one more question. Mike, what happens if some point in the future B demolishes his house and he sells the land to he sells C to a third party, right? So now, not only can the owner of C cross B, he can cross A. What does that make B? What happens to the estate of B at that point? Is that dominant now or servient? Yeah, so you see what actually happens here. B is now servient to C. And if someone buys C later, a third party, there's now a diminution in value of the B property. Everyone see that? Yeah.
Well, I thought the court ruled that as long as it's used for the one house purpose. So wouldn't that be in the easement?
So, reading the court's ruling narrowly, yes, but let's use our imagination for a second, right? Let's assume that B builds a house entirely, the house is built entirely here, and a house is built entirely here. Why can't C come back with the exact same argument, saying, hey, wait a minute, I can't get the land? Exactly. So now, if this came back to court in the future, they'd have to make B servient as well. You see what happens when you start messing with these easements, right? And this is a long stretch from the, absolutely necessary, because the court says, listen, we'll put one right there. We'll extend it. Okay. And I believe, instead of a-hole, the word they use in the reading is the most scumbaggiest person I've ever met, which I guess is probably worse. Okay. Any questions in that case? Hey, Zoe.
Yeah, I was just wondering, how is this even an issue if they're using the easement? What if they're using the easement to get to B? Can't they just argue, hey, we're using this to get to B, and then we're just walking on to C from B? We just use the easement to get the stuff to B.
But it's for the owner of B, right? It's an easement appurtenance, not an easement engrossed.
Right. So what if they just took all of the stuff they were using to build the house? They parked it all on lot B for a few days. Then they were only using the easement across A to get to parcel B.
But still, it's for the benefit of C. You see, it's hyper-technical, right? It's for the benefit of C, not for the benefit of B, and that doesn't fit under the easement appurtenance. Any questions on this one before we move on? All right. So the last case we'll do today is called Presault, the U.S. And let me give you a little bit of background before I go too deep into this case, because it's actually fairly interesting facts. So there were lots of railroads in this country at one point. And in order to obtain these railroads, railroad companies had to purchase easements from farmers or whomever so they can cross their land. Also, in many cases, the government used the power of eminent domain to seize the land and basically hand them over to the railroads because they were considered public utilities. Same way you could seize land to build a road, you could also seize land to build a railroad, right? So there were these thousands and thousands of easements for railroads across the country. But many of these railroads were abandoned. We simply don't have as many lines today as we once did. I mean, when was the last time anyone in this room took a train? Exactly. Yeah. Yeah, exactly. So we don't use trains anymore, okay? So some genius in Congress, and there's always some genius, has this idea saying, I got an idea. We have all these abandoned railroads, which are usually cleared out paths and they're not being used. Why don't we convert them to trails, nature trails, so people can hike on them, right? Okay, light rail doesn't count. So this idea was, okay, let's just turn these expired, railway tracks into trails. There's a problem with this, though. Many of these easements that were granted 100 years ago were given for the specific purpose of a railroad, not for hiking trails. So the same way in the first case, when you have an easement for bathing, for fishing and boating, it doesn't include bathing. Here you had easements for railroads, not for hiking. So under the normal doctrine, could the government allow people to hike on an easement that was reserved for railroads? What do you think, Zach? Under the normal circumstance, the easement says only to be used for railroad purposes. Could people hike along it? No. The answer is no. What happens if the government lets people hike along it anyway? It's a misuse of the easement. All right, so the good news and bad news, right? If the government, Parsha, if the government wanted to convert all these railroad easements to hiking easements, could they do that? How would they have to do that? Oh, they created the law, but beyond that, under the United States Constitution, if the government wanted to convert those easements from railroad to hiking, what would they have to do? We haven't covered this yet, but anyone know what they'd have to do? Yeah. They'd have to pay for it. They'd have to pay for it, right? So under the Constitution, the Fifth Amendment, the Takings Clause, right? The government can take a private land for public use with just compensation, right? So if the government really wanted to convert all these railroad easements to trail easements, and they can pass a law and initiate proceedings to basically compensate the easement holders, saying, hey, listen, we're going to take all of your land, we're going to now make it to trails, and we're going to buy the value of the easement from you. Yeah.
Once the law is enacted, if a property owner is just being really stubborn and won't sell, can the government use that law to enforce like a reasonable offer to be accepted?
Well, okay, so two things. When the government first passed this law, the rails to trails, they obviously didn't read the Fifth Amendment. They're very good at that in Congress, right? They didn't think that. They thought they could just wave their magic wand and designate these rails to be trails, right? That didn't happen. And the Supreme Court resolved this in a case. Oh, what the heck was the name of it? It was an O'Connor opinion. Yeah. Oh, same name. Yeah, Presault versus ICC. So there's actually a Supreme Court case where the Supreme Court said, listen, the government can pass this law. That's not a problem. The issue is if you want to start converting railroad easements to trail easements, you've now constituted taking. You have deprived them of the value of their property, right? They had these sticks in the bundle, you just took a stick out, right? Now people can also cross across this. That's fine, but you have to pay for it. The government didn't want to pay for any of this, right? The government thought this was free money, which is usually what governments do. They go, oh yeah, no problem. We can just wave our magic wand in Congress and take it, right? So by 2002, there were over 4,500 people claiming money under these rail to trails easements, right? Now, there are over 8,000 people claiming money under these rails to trails easements. And the amount of money is in the tens of millions of dollars. Because these are very, very long easements over long stretches of land that now need to be compensated. All right? So the case you're studying here was actually a case from the Federal Circuit, which is a court you might have never heard of. It's a court you may have never actually heard of. So there are 13 federal courts of appeals in the United States, right? Most of them are geographical, right? So 1 through 11 are the geographical courts of appeals. Like the First Circuit is based in Boston. The Second Circuit is based in New York. Third Circuit's Philadelphia. Fourth Circuit's in Richmond, Virginia. Fifth Circuit is in New Orleans. Sixth Circuit's in Cincinnati. Seventh Circuit's in Chicago. Eighth Circuit's in St. Louis. Ninth Circuit's in San Francisco. The 10th Circuit's in Kansas City. The 11th Circuit is in Atlanta. Okay. Then we get to the DC Circuit, right? The DC Circuit, which is in DC, and the Federal Circuit, which is also located in DC. But the Federal Circuit is a very specific jurisdiction, right? They have jurisdiction over intellectual property cases and, for your purposes, these rail to trails cases. Okay? So this is a case that's being appealed where the owner, Presault, of a piece of land is challenging them, saying, hey, listen, my easement has nothing to do with trails. If you want this land, you got to pay me for it. Okay? So that's the background of this case. It was actually a rails to trail case last year at the Supreme Court, which was so disappointing because it didn't actually do anything interesting. I was so excited about it, but there wasn't much there, so I won't even bother mentioning it. Okay? So we're faced with this easement, right? That was granted in the year 1899. So this railroad got this easement to use as a railroad. And we have this language. Okay? Where is it? Okay. So it says that the railroad has it for, quote, constructing, maintaining, I'll write it out so we can refer to it because I looked to a lot. So it says, there's no 14th Circuit. constructing, maintaining, and operating a railroad. Oh, my space bar is not working. For public use in the conveyance of persons by the power of steam or otherwise. Okay. So the court is faced with this easement, which was from 1899. And they have to determine what is the scope of this easement, right? What's the scope of this easement? So the first question they have to resolve, which is actually fairly easy. Okay. Does this result in a conveyance in fee simple? Andrew, is this a conveyance in fee simple? That's right. Yeah, this is obviously not a conveyance in fee simple, right? The railroad did not get this in fee simple absolute. That much is clear. But the second question is, what's the scope of this easement? All right, so Andrew, read this out loud. So it says constructing, maintaining, and operating a railroad for public use and the conveyance of persons and property by the power of steam and otherwise. Does this, what do you think this entails? And look just only at this text. What does that suggest to you is the purpose of this easement? Don't laugh. No, that's okay. Okay, I'll leave you alone. Is it allergies or? This will probably happen at some point this semester. I'll lose my voice for allergies, so I will take preemptive compassion. Okay. What was that? Okay. So at its face, at a minimum, this seems to suggest that this easement can be used to construct, maintain, and operate a railroad, right? Let's see, Zach, what happens if someone wanted to build, I don't know, a hover train? You know what that is? Everyone know what a hover train is? There's no actual wheels, kind of hovers with magnetic levitation, like a maglev. What if you wanted to build a maglev on this? Could you do that? Oh, well, based on this, where does it say purpose? It says constructing, maintaining, operating a railroad. Where does it say anything about a purpose?
I think that would just kind of be assumed because that's the whole railroad there in the first place.
Michelle, what if someone wanted to build a highway on there to allow cars to drive? Would that be permissible? Why not?
I mean, you don't associate cars with a railroad at all.
But isn't the purpose conveying people?
Well, it says by power of steam or otherwise.
Or otherwise? Yeah, so gasoline, is that not otherwise? What if the highway was owned by a railroad? What if, like, you know, the Western Union Pacific owned the highway?
I still don't think so.
What do you think there? What if the Union Pacific owned the highway and they let people drive? They said, screw this, cars are stupid, we're gonna let people drive.
I think it's definitely construed in favor of the railroad company, like to give them more.
Why would you do that?
It gives them some open-ended argument, maybe, to do something else.
What else? Garrett, you're really itching.
Well, it says operation of a railroad. So I don't think a railroad company could just decide to build a highway because that's not a railroad.
So
but I would disagree about the maglev because that's just a different type of railroad.
Well, Garrett, let me throw this back at you. In 1899, when this was drafted, right? Did anyone know what the hell a maglev was?
They certainly did.
So could they possibly anticipated that a maglev would be on this road?
No, but maybe in the modern context.
Yeah, but well, so what's our frame of reference for easements? Are we basing it on the time when the thing was drafted? Are we basing it on modern times? Oh, it's a question. It's a question for the next few minutes we'll be talking about. Who else? Who else has got something? Yeah.
Yes, maybe the person is probably concerned with the traffic. How many people would come to there? I don't feel like they would see too many people or like be so disturbed by people on the train.
Where do you get that from?
Well,
I'm only looking. This is all we have. People who wrote this are long dead. They're gone. All we have is this one sentence.
What you said about cars, you allow people individually to copy. Train is just.
What happens, Shamira, if the Union Pacific Company opened up a running track? Would that be included? What if they open up a track to run on? By means otherwise, your feet? Zoe.
I think we should more look at the scope of the land conveyed. Say if we're doing a railroad or if we're doing a highway, in both cases you have trains and you have cars, and they're going to stay on the railroad or they're going to stay on the highway, at least, most of the time, unless the driver's drunk or something. But I mean, if you have a running track or a nature trail, well, then that's people walking or running. And you know what? They might stray off the path and onto the private property.
Where do you get all this from, Zoe? You just said a lot of interesting things. Do you see any of that right here in these 4 lines? Everything you said is completely valid. Where do you get that from?
It's in the case.
I'm not talking about the case. I'm just looking at these words. That's all. I mean, you're now a court. This class is a court.
It says public use.
Public use. So, what does that mean, public use?
I guess it kind of means for, if you take it in terms of the, taking this law for the benefit of the public.
Mm-hmm.
And, but in the context of a railroad that is limited in, scope, and when you think of a railroad, that's about it. It goes, it's on tracks for the most part, and so there's no.
So maglev wouldn't be covered.
It would. I think it would. Yeah.
So there's a very famous legal thought experiment by a professor named H.L.A. Hart, and you may have read this or not. I'm not sure. So you go up to a park, you see a sign that says "No vehicles allowed." No vehicles in the park. Unless you think this is purely fictional, a couple years ago, I was at Golden Gate Park, and I saw the sign. I was like, "Oh my God!" See, it says "No vehicles in the park." Okay. Now I want you to look very closely. Very closely. What's up the hill? See if I can pick it out. In the next frame, that bike almost knocked me over. Okay? You can't see. The other flame is too blurry, right? But there's a biker up here, and this is San Francisco. These are steep hills. In the next frame, dude's here, and I almost get run over. Okay? So I say, "Hey, no vehicles in the park. What are you doing in there?" Oh. David, am I right? No vehicles in the park is a bicycle vehicle? Oh.
It's not a motor vehicle.
That's not what the sign says. The sign says no vehicle. It's all just 2 words, no vehicles. That's all the sign says. No park rangers there. They were defending the president or something. I don't know.
I would consider a bike a vehicle.
Why not? What's a vehicle?
It's a closed. I don't know.
Okay, so now we're getting to an interesting question of statutory interpretation, right? This is an interesting statutory interpretation. What is a vehicle, Blaine?
Well, I would think, in my mind, a vehicle is something that helps you transport from one place to another.
Like a bicycle. So no bicycles allowed in the park.
I would think that would be.
I agree with you. Dude almost ran me over. Very dangerous. Stephen, what do you think? No vehicles in the park. So is a vehicle merely a means of transporting one place to another, as Blaine said a second ago?
I think so. I think it comes down to what the definition of a vehicle is.
That's what I'm asking you.
I think and I'm answering that I think a vehicle moves a person.
So you think
Being closed, doesn't have to have 4 wheels, doesn't have to. I
So-
think that's included in the definition.
so you think it'll be okay to ban bicycles based on the sign,
I believe so.
right? Stephen, what do you think? Everyone hands down. We'll get to. Yeah, Alex. Sorry, Alex. Yeah.
I agree with Steven. I mean, if it's used to transport from A to B, if it's used to transport people from A to B, then I think it's a vehicle. So
Okay, so you see what's interesting here, right? We have different ways of reading a sign. We have different ways of reading a sign, okay? If you are trying to be extremely literal and you define the word vehicles as many of you do, it simply means a mode of conveyance from A to B, right? Zuhei, Let me ask you this question. When the Parks Department put the sign up, what do you think they had in mind for vehicle? This is a different question. When the Parks Department put up the sign, what do you think they had in mind for vehicles? Motor vehicles, right? Why no motor vehicles?
Space is probably limited of people walking, so for safety reasons.
Yeah, Danielle, what do you think when they said no vehicles? What do you think they meant?
I think they meant no motor.
Okay. All right, Zoe, you can jump. Go.
I was just worried, 'cause I mean, I think that the bike should count as a vehicle, but I was worried about the whole any mode of conveyance, because if we went with the whole any mode of conveyance thing as a vehicle, well, then wheelchairs would also be banned.
Okay. Let me ask you, Blaine or Stephen, what about a baby carriage? Blaine, would a baby carriage be banned? Would a wheelchair be banned? Is that a mode of conveyance? Either one.
I think that it would be banned under our interpretation of the rule. But when it comes to construing a deed, which is essentially a contractual agreement between two persons, well, we've got to respect the intent of the parties, and the best way to do that without introducing extrinsic evidence is to read the words, the explicit words of the document.
Okay, so this is a good exercise in statutory interpretation. That the way to give intent, the way to give effect to the intent of the parties is to read the words. Isn't the way to give intent to the parties to figure out what their purpose was? See, there's different ways of reading a statute or an easement or a deed or whatever else. It says vehicle. We can say, okay, how do people understand the word vehicle? What's the generally reasonable understanding of the word vehicle, right? Or we can say, what did the Parks Department probably mean when they put the sign up at this park, right? Right? So a few more hands over before. Yeah.
Well, so like, I think this applies to like the Jusdom generis, and like we use the common meaning prevails unless there's some other explicit meaning here. It's like exclusio, expressio.
Yes. Oh, now you're speaking my language. Expressio unius s exclusio ulterior s. Yeah. Google it, someone. What do those things mean? Expressio unius.
So in this context, it means like in statute or some other situation when they say one thing, they're implying that everything else is excluded. And that's just a general rule of statutory.
Good. So let's say like this. Like let's say the sign said no vehicles in the park, such as cars, motorcycles, and go-karts, whatever, right? No, this little like power wheels vehicle when you were a kid. I never had one. What? Yeah. What? Yeah, the little RVs, whatever, right? So, Tyler, if this was the sign, so no vehicles in the park such as cars, motorcycles, and go-karts, whatever, right? Would you have any doubt that a bicycle be permitted? How come?
It's not a car, motorcycle, or go-kart.
Yes. So there's this canon of construction, which you brought, I think I'm spelling it wrong, but it's a justum generis, which basically means you judge a statute based on what surrounds it, right? So if you have cars, motorcycles, go-karts, it's safe to assume that, like an RV would not be allowed. And it's safe to assume that a bicycle would be allowed.
I was going to say, or even it's not similar to anything on the list either.
Mm-hmm. Yeah. Yeah, exactly. Yeah.
I think what they meant was by a vehicle, something to determine combustion engine.
Where do you get that from?
Well, I mean, even they put that ticket sign in order to keep a car or a truck or large vehicle from passing.
Motorcycle could fit just fine.
Motorcycle, but the purpose is kind of keep the sound down.
So now we're moving from the actual text itself to purpose, right? How do you figure out what the Parks Department purpose was? How do you get in their heads?
What's their mission statement? What's their job?
Right.
Kind of keep the park
Clean, not so noisy, right?
I was thinking, depending on how big the park is, they may want one of their purposes may be to discourage people from driving RVs onto it and camping illegally.
Good. All right, Morgan. What about a horse? Could you bring a horse onto that hill? Would a horse be a vehicle? How is a horse a vehicle? That horsepower. I mean, how is a horse a vehicle? Maybe one time of year during the rodeo was the rodeo stampede. Let me tell you something else, Morgan. Samaya, let me give you this example, okay? Let's assume that this sign right here was written in the year 1860, and this is a beautiful sign that's been maintained in the exact same spot since the year 1860. Could I ride a horse into that park? Would that change the situation? Why not? Do you think the people who wrote that sign in 1860 thought about vehicles as a horse as a form of vehicle? No? You see a difference between having the sign today versus having the sign written 150 years ago. Right? Expectations change. Where today, most people probably wouldn't think of a horse as a vehicle. Maybe perhaps Morgan does, but I think of it as like, some sort of a hobby or something, right? I would not think that people actually use a horse in the year 2014 in San Francisco to actually go from place to place, right? But if we know this sign is much older, we base our understanding on the expectations of those who drafted it. If you haven't studied this in common law yet, you will, right? This is the modern doctrine of originalism, right? We try to understand how the drafters of a bill, how people at that time would have understood what it meant, right? Let's say, I can all the way around, tie. Let's think about this one, right? What happens if I say in the year 1860 they could never conceive of cars, and so therefore cars are allowed? How would you reply to that?
I would say no.
Why not?
Because the car's a vehicle. I mean, I'd say cars would be more so than a horse.
What if we find the reason why they put that sign up was because they were tired of horses pooping everywhere? Like that was their purpose, right? We find the history. They were sick and tired of these horses pooping everywhere. That's the only reason they put the sign up. Because in 1860, that was the only vehicle. You had horses, you had carriages, it was all horse-drawn. Why do you think they have a problem with, cars or bicycles?
Cars and bicycles normally do that, but cars like smell and stuff.
Bicycles.
Bicycles good.
They know about bicycles, though. You see the problem, right? There's no right answer to this. This is why law students for 100 years have been doing this exact same question, right? You try to figure out, how would they have understood this 150 years ago? What was the vehicle understood then? What was the purpose? How would they have expected their sign to apply to modern day situations? They couldn't have conceived of a car that didn't exist yet, right? Here you go.
Instead of being exclusive, instead only walking allowed.
Oh, well, they could have said only walking allowed. Would that have included crutches or wheelchairs? What else?
Okay, guys, stand up.
What else? Good. Zoe.
Well, what if they couldn't have reasonably conceived of it at the time? Well, what if you tried to employ it to say, if they did know, like, if somehow someone went back in time and explained to them what a car was, would they, by their standards, think that was a vehicle, or would they think it was something else?
Well, if I could give an example in other context, right? I'll give an example from common law, which you'll say soon enough, right? The framers of the First Amendment had no idea what an internet was. They couldn't have conceived what an internet was. They knew what a newspaper was, right? Is it that crazy to think that whatever protections would apply to a newspaper in the year 1791 should apply to an internet website, right? I don't think it's so crazy, but that answer actually isn't so self-evident. Yep. All right. Other thoughts before I wrap up the case. This is much more interesting than the actual easement issue, but I love doing this because you don't get a class in legislation or statutory interpretation ever. So this is your little 15 minutes of fame, right? So the court basically said, you know what? No, segways do not count, okay? Who takes Segway tours of Houston? Why would you do that? I can't fathom, where do they go? It's like, there's a highway, and there's another highway, and there's a building. I don't mind Segways. Like in San Antonio, I think it makes sense. Here, it's like, anyway. If they're in the Alamo area, I like that area. It's nice, around the Riverwalk. Okay, whatever. So basically, the court looks at this language, right? Does this constitute an easement for running? I think the answer is no. The answer has to be no, for the very simple reason that it says railroad, talks about steam. Steam is usually not people running. And I think Zoe made a good point before. Having a train go by doesn't include people wandering onto your property and like taking stuff or taking selfies in the woods, whatever people do nowadays, right? That would not happen. People dropping their Gatorades, whatever. So I think it's a very different use. The court also looks at whether the easements were. It says no, right? The easements are still there. So there was a taking, and if the government actually wants to use this as a trail, they got to pay for it. And on remand, they think they found over $200,000 in costs to convert this railroad easement to now a trail easement. Okay. Ooh, all right. Questions on this? All right. Have a wonderful day. I will see all of you on Wednesday.